This week, we're shocked by a series of denied bails that were happening in our TV screens, our phones, our laptops, wherever you were watching the proceedings.
Magistrate court refusal to grant bail is hereby refused.
Therefore, interest of justice does not permit his release.
His application to be released on bail is refused.
And these people have something in common. There's a common reason why they were all denied bail. It's not a coincidence. It happens especially when you decide to lie to the courts without even giving them the reasons why they should trust you in getting the bail. It is not justice denied. It is just the rightful decisions that the magistrates and our courts had to do in light of everything that is happening in our country. In this video, I wanted us to look at the 4 cases that have been in our screen this week. The case of Matipandile Sotheni, Sergeant Fani Nkosi, Captain Laurence Makgotloe, as well as Mogotsi.
I also found an IP's report. An IP's report is an automatic ballistic integrated system report. It's where you acquire certain exhibits to be put in the system to check if they are not linking with other cases. What was done by Matipandile. I found that report in this house, and it was dated 2025-07-17.
2025?
2025-07-17. And it was saving those cases of DJ Sumbody, DJ Fani, which I mentioned earlier, that are linking to those firearms that were found in Breadwinner.
One of the questions you might ask yourself is why 3 of the 4 were denied bail? What is it that they did wrong? And I can tell you that there's one reason for all 3. And the reason is that they will evade trial, meaning that they are flight risk. That's the first reason. The second reason is that all of them, they basically lied before the courts during their bail application. And one thing I can tell you is that you don't want to lie to the courts during the bail application and also during the trial proceedings. Because if you lie to the courts and the courts finds out that you actually lied during the time of sentencing, when they have to look at the mitigating factors, they're going to use that to say that you showed no remorse and you lied to the courts. And adding that, it looks like you did not have remorse. But with the bail application, it just shows that there's something that you are hiding. And if you were to be released, you ensure that you don't go back to prison. And you do anything in your power to not go back to prison. So before we can go further, this is what I'm going to do in this video. I'm going to first focus on the bail application of Sergeant Nkosi and Captain Makgotloe, because there's a lot of similarities between these 2 cases. Then I will conclude by talking about Matipandile and Mogotsi, because they have the most similarities more than the other 2. So let me first start with Sergeant Nkosi and the arguments that were made before the courts. So we know that he started the magistrate's court and the bail was denied by Magistrate Teledi. And then he appealed to the higher court, of which still in the higher court, his bail application was still denied.
I see no need to interfere with the judgment of the bail court, as the magistrate did not exercise his discretion wrongly. This appeal ought not to succeed. The order in the RAS, I make the following order. 1. The appeal against the Pretoria North Magistrate Court refusal to grant bail is hereby refused.
And the biggest reason here is the issue of what the police found when they went in his property. We know that during the raid, they found the 52,000 rands, they found the ammunitions, they found the firearms, and they also found the cash in transit dockets. And that in and of itself, it makes you ask questions as to how did this sergeant actually find himself having possession of these material? These people literally were keeping the entire case in their houses, because the question remains, even if you are working on this particular case, isn't it that the best option would be for you to actually keep this information in the office? Why bring the information in your home? And that is a red flag in and of itself. So the legal counsel of Mr. Fani Nkosi made arguments regarding the fact that there is a possibility and that he won't actually commit these things or the factors that are being considered whenever you've committed a Schedule 5 or Schedule 6 offense, where we have to look at the factors as well as the exceptional circumstances of whether they exist.
Release on bail may commit a Schedule 1 offense. He has a suspicion to evade trial, and then also in respect of the financial resources that could assist in evading prosecution. And from there onwards, my lord, if one have regard to 15.3, he may interfere with the investigations of the evidence, and he might interfere with them. That's with witnesses, my lord. And then in paragraph 15.4, there's a concern that the appellant might attempt to interfere with evidence, police administrative systems, case dockets or exhibits. And then in 15.5, my lord, raise serious concern regarding possible interference. The reason why I've highlighted all that, my lord, is because from that the only reasonable conclusion that one can reach is that the state says there's a possibility of any of what we say that might happen. They don't provide also to the bail court any substantive reasons of a probability or a likelihood of any of those circumstances.
So looking at all of that, the Fani Nkosi and his counsel then concluded that there is no guarantee that actually all of these things Fani Nkosi is going to do, that is going to evade trial, intimidate witnesses, interfere with investigations, even though the state argued that looking at the fact that this person was found with dockets, with money, he's capable, he has the money to ensure that he escapes, he doesn't come to his proceedings, he evades trial, and that he can interfere with the investigation.
This information was not samsaked. It was indeed evidence that was collected by the investigating officer. And on that basis, my lord, we as the state or respondent have a very strong case against the appellant. We're talking big money here. I mean, 300 and something thousand. It's not a child's play. Having more than 50,000 in your household is not something that is common. And we're talking about someone who declared his salary as being in the region of 16,000 rands. We're talking about someone that hasn't actually indicated anything about having business interests. And therefore, it is my humble submission on that aspect that he's moneyed, he's got cash.
That is the biggest issue here, that he might interfere with the investigation in light of the fact that he was found with the dockets, which is similar to the forensic specialist or forensic expert, which is Laurence Makgotloe. Here, Laurence Makgotloe also, the same arguments were advanced in court yesterday. So Laurence Makgotloe also was raided, and in his house they found a safe, and in the safe there were 23 ballistic reports. And they also found ammunition, and they also found one ammunition, this very special ammunition that you only need a permit for you to have it. And that ammunition, the way they described it is that it's the one that when they fire at a particular victim, it comes into the body and it erupts. So that particular ammunition, for you to actually have it, you need to have a certain documentation which allows you to have that particular ammunition. They also said that they found firearms there and many other things that the state argued that they found.
Just to perhaps clarify it further, one officer. Even if one would accept that they were issued to him for whatever purpose, would such tests be done at his house?
No. They were not supposed to be at his house. They were supposed to be at his workplace.
Okay. When I interrupted, you were still listing what you found. What else did you find?
On the search we found one ammunition for a shotgun. The shotgun which is those ammunition gun normally used by to disperse the crowd. But this one was not, it was a live ammunition, that means it was a strong, the real one, not those pallet ones.
Does one need to possess license to have those?
That's correct.
What else do you find?
On further search, we found 13 rifle ammunition that were in the 18 that were in the safe. They were sealed in an exhibit bag, but this exhibit bag is not even written outside for what is the purpose of it. Normally in an exhibit you write the case number, the station, as well as the signature or the SAP number, where are they coming from. But it was a claim exhibit sealed with those 18 rifle ammunition.
Provide any answer or explanation for such possession?
No.
Did you ask him?
Yes, I did.
And what was his answer?
He acted shocked.
And most importantly here, what I've heard from the arguments that have been raised by the legal representatives of Fani Nkosi is of Laurence Makgotloe, is that these things he had them without a permit, and when he was asked, he said he doesn't have a permit, and sometimes he could not even answer the questions that they would have for him. What makes the matters worse is that they found a ballistic report that is linking to the unaliving of DJ Sumbody. You might think that it's not that deep, guys. Remember, this is a man who told witness A and witness B that actually these cases are linked. There is this case of Armand Swart is linked to high-profile cases. There's a high chance that this firearm that they confiscated is linked to other high-profile cases, only to find out that Makgotloe changed the story after he amended and fixed the errors, which there were errors again. It was revealed that there is no link to other high-profile cases. Now we see this man having a ballistic report that is linked to DJ Sumbody. DJ Sumbody, who is, it has been alleged that is unalived by Katiso Molefe, Kekana, and Mabusela. Also, Armand Swart, the same suspects are there, including Michael Pule Dau in that particular dock.
Now that he had given a number of reports, the first one was questioned, the second one, and then the police were seeking the third one. Which one of those reports was found in his house?
The one of the 24th of May, first one.
You found it in his house?
Found it in his house.
Is it the one that you said had omitted analyzing the 15 cartridge cases?
That is correct.
And just further for clarity, this ABIS that you are talking about of the 17th of July, 2025, and you say that it also linked the case of DJ Sumbody and others. Did it have any class number?
It was having the Breadwinner as 149 of 4, 2024.
That is one of those cases that were assigned to him.
That's correct.
So now this person is dealing with these cases. There's no link. He said there's no link, but it just so happens that he has the ballistic report of DJ Sumbody, linking to DJ Sumbody. What makes the matters worse is that this person had an IBIS report in the case of Armand Swart, and also that he was not supposed to have, because when you look at the consultation that he had with witness A and witness B, he had a meeting in May, and the IBIS report came in June. This guy literally, guys, there's just a lot of elements that show that he was literally trying to conceal. He was trying to bury certain evidence. He was trying to tamper with the ballistic reports.
Let's just go back with the leave of the court worship. I want just to clarify something. At the time that the investigating officers went to him for the first time after General Shibiri informed them that the report was ready, you say that it was in May.
That's correct.
And then the report of ABIS is dated 17 July.
That's correct.
And then you told the court that he had informed them that this case was linking to other high-profile cases. Now, if this report, I just want to comment on this. If this ABIS report linking to Bramley 149 was dated 17 July 2025, how would he have known about the linkage when he first met the investigating officers without the ABIS report?
The ABIS and ballistic analysis are two different things. You start with analyzing the ballistic side of it. Then once you finish your report and say that you send it over to ABIS to analyze. ABIS is going to issue another report, different to the primary report. Usually you see those reports, they will come with the phase 1 of the report and phase 2. That means that these two reports are coming. Then the ABIS one will come with a list of cases that are linking. Then the normal one will not come with it. Then we come to the point. There is no way at that stage when the investigating officers were in his office collecting the report, he would have known that those firearms are linking to other high-profile cases or others because of the ABIS was not acquired at that time. The only way that could come to my conclusion was that he would have known that maybe I was told by one of the suspects that I was going to link to those cases.
I get why the state argues that actually should not be given bail, because that is a clear example of tampering with evidence. Because if you have the ballistic reports of DJ Sumbody And you also have the IBIS report of Armand Swart. And later it was revealed that the firearm used in DJ Sumbody is the firearm used in Armand Swart. There's a link, but you didn't find any link. When did you realize that there's a link? Because you're having the ballistic report of Armand Swart, you're having the ballistic report of DJ Sumbody, you even have the IBIS reports, but you can't come and tell us where is the link, which gets to show you. That is what I'm saying, that he says that there's some kind of argument that you can raise that he did, in a way, try to tamper with the ballistic reports in that case. And another thing is that this is not the only case. There's another case of 2018. I think it was Tongeni or something like that. The same thing happened. He had a lot of errors with these ballistic reports. So here the main argument is that Makgotloe deliberately wrote flawed reports and omitted 15 spent cartridges. Why? It was to hide the fact that this specific weapon linked back to 30 other high-profile hits, including the brutal assassination of DJ Sumbody. So they found 38 rounds of ammunition and stolen ballistic files. To kill his bail application completely, the state dropped a bombshell. They found evidence of him doing the exact same thing in 2018. And the cost perspective is that if a man controls the ballistic data, letting him out is letting him erase that particular evidence. So that is what is going on with this case of Mr. Makgotloe. But that's the thing. According to the defense, all of this is just human errors, and that anyone can make these errors, and that it is probable for anyone to make the errors.
Your narrative that you want this court to take note of and to believe is that these mistakes, inter alia, it's not all, but these mistakes were done deliberately by the applicant before court. Correct? That is correct. I'm putting it to you. They were honest human errors.
That's not correct.
Honest human errors going through different processes, reviewed by different people in different divisions of the criminal justice system.
Never allowed to make any mistake in a report.
The human beings are too allowed, worship, to make mistakes, but it depends what effect those mistakes are going to make and how huge are those mistakes are going to make. An expert of his caliber, with so much experience and so much qualifications, he cannot make such mistakes. Repeated mistakes, no worship.
Even though Makgotloe did agree that if these errors are made, they will jeopardize with the case and they will jeopardize with the justice system. So currently the matter has been postponed to next week, Tuesday, if I'm not mistaken, and we're still going to hear more arguments that are going to be raised and some cross-examination and some probing more of this particular case and whether bail will actually be granted. That is when we'll find out what actually happens. But I think so far it really does not look good for the captain, even though the defense is strong, bringing really strong arguments at the same time. But I also think that high chances he might also not get bail, because courts are moved by precedents. Courts don't just make their own rulings just in vacuum. They are pushed and they are controlled by precedents. And already with the case of Fani Nkosi, we see the precedents that has been set. Either the court is going to set another new precedents, or they're going to follow the reasoning in the case of Fani Nkosi, deny him bail, because the reasons are still not yet clear as to how did he have been in possession of these ballistic reports. They have tried to say that it's because of his work, he's working in these cases, but still I don't think that is enough for us to say that, okay, now this person deserves the bail. Because as I've said, it doesn't make sense. Even though you can work on the cases, are you all working on these cases? But you are the first person that said there's no link with the DJ Sumbody case. And this case of Armand Swart, remember, you even went to Mazimdoti. That's when they found the link with the case of DJ Sumbody. Why then are you having the IBIS reports of those cases and the dockets of those cases, the ballistic reports? According to the defense, they say that it was in preparation for the Matlanga Commission appearance. We don't know what actually happened.
He had more ammunition than what he was supposed to have with his 9mm state-issued firearm. That's correct. And then there were also other ammunition for which he does not hold a license to possess such a fire. That's correct. Right. I'm going to put it to you that as a ballistic expert doing examinations, The applicant and other ballistic analysts at the laboratory are issued with ammunition on a monthly basis by Colonel Mogotsi to use in test purposes.
That is the case, Worship, that ammunition is not issued to use them in their house. It's issued them to use at work, not in their houses.
Nonetheless, guys, let me hear what you think about these cases. Let me now move to the case of Mogotsi as well as Matipandile Sotheni, starting with Matipandile Sotheni. You see, with these two individuals, the first similarity is that, number one, they have the same counsel. And this lady literally was trending even yesterday on Twitter to say she did the good thing because she put the brothers away. Of which I don't know if that's a good thing or not, but she did the good thing by putting the brothers away. And then the second argument, the second similarity here is that these people, both of them, they've lied a lot about their personal circumstances. And that is I can't stress that enough. That is very important whenever you're dealing with bail application. You can't bosh your personal circumstances. They have to be very precise, straightforward, and they have to be clear. It's not now about what you've done, your personal circumstances. That's the first point where they got it wrong. Despite the allegations that they have against them, the fact that they provided wrong personal circumstances is what became a problem. With Matipandile, he went there, he lied. He said he's a breadwinner, his family relies on him, and that, yes, he was in the Brakpan area during the unaliving of witness D. Marius van der Merwe, and that he knew that his friend was actually implicated at the Madlaga Commission, and he went to his friend at that time when his friend was implicated at the Madlaga Commission, who later on is a suspect in this unaliving of a witness D, which is Marius van der Merwe. The court's ratio was mostly based on the fact that this guy lied about that. He's not the breadwinner. The mothers of his children actually take care of his children. They take them to school even though they don't know these women's sources of income, especially the wife. But they take care of their children. And that literally, Matipandile is a deadbeat. That's literally what the court was saying. That is a deadbeat. He's not taking care of his children. That his children are taken care of by the mothers. He's literally those guys who just don't want to work and they just want women to take care of themselves. And then now and again, they take piece jobs, do whatever. And then for the longest of time, they're just sitting at home. They're driving the woman's car, staying in the woman's house. They eat the woman's food. All of that. Literally, that is the way the court painted him. It's not me. It's the way the court painted him.
Able to determine from the lack of any further details on his family background and from the information provided by the investigating officer that he is not the primary caregiver of his two minor children. Their mother is employed at PRASA. There was no indication that the children will suffer in any way should the applicant's detention continue. The applicant did not disclose the girlfriend's child as his. In any event, the girlfriend is also employed, and there was no indication by the applicant of the role he plays in the life of the girlfriend's child. The applicant attempted to have a second bite at the cherry by supplementing his personal particulars, as appears from paragraphs B to D of the replying or supplementary affidavit. This did not elevate his personal circumstances in that he is still not a breadwinner in his primary family.
And also, there's too much coincidences that this person, he was in the vicinity when Witness D died, and when Witness D was unalived, all of those things. The court considered them and said that, no, you are a flight risk. You will evade trial, and therefore we will not give you bail. Since he has to prove that there exist exceptional circumstances, he failed, because that's what the defense said, that he failed to prove these exceptional circumstances, including the courts. So that he failed to prove exceptional circumstances. Then they pointed out to one of the very most important thing, and that is his skill. This skill of being able to be, the skill that he acquired from this being part of a special task force. And that skill is the one that they say that if he keeps on doing, if he gets released, he might get a job internationally and he might leave the country. Also, they spoke about the witnesses, that this person knows witnesses. And if these witnesses, he knows them, anything happens, he might then tamper with the evidence or intimidate those particular witnesses.
The personal circumstances of the applicant are considered cumulatively. I am satisfied that the facts have established that the interests of justice do not permit the release of the applicant from detention. I find that the applicant failed to discharge the honors and to demonstrate to the court that there are exceptional circumstances which, in the interest of justice, permits his release on bail. His application to be released on bail is refused.
And that is the reason why Matipandile did not get his bail. It's because he lied about his personal circumstances, which is the exact same thing that Mogotsi did. Mogotsi came, lied about his residence, gave 2 different residences, and even said that he has a lease agreement with the landlord, which later it was revealed that actually these might be 2 different addresses that are not even related, because the police officers and the IOs that are actually involved in this case kept on going to the property and they would not find Mogotsi there, which then made them to make a conclusion that he does not even stay in that particular place, despite the fact that he did try to bribe an officer and agreed, but literally changed it and said he wanted to help him with the investigation instead of a bribe. All of these allegations, the biggest issue here of the magistrate was the issue of his address, that his address was not properly captured, which then signals to the issue of evading trial, meaning that he's also a flight risk, because they've been trying to get hold of him for many times and he knew. But the defense argument was that all of this was because Mogotsi didn't trust anybody. There was an attempt assassination on him. Therefore, the investigative officer, he could not even trust an investigative officer at that particular time.
The court cannot accept the applicant version that it is an error by the landlord to write a wrong address as house number 4454 in the lease agreement. The applicant failed to call this landlord, Mr. Nkosi, to confirm that indeed they have this agreement, the lease agreement. Therefore, the court found that there is no proper address for the applicant, and it will be difficult for the state to trace him, and there may be a likelihood that he will evade his trial. Therefore, interest of justice does not permit his release, as there is no proper address.
And this is the reason why the court said that you will not get the bail. Obviously, the too much talking legal representative of Mogotsi reveals that they're going to appeal this decision, of which I did assume this in my first video when I did speak about the summary of the bail application of Mogotsi, that high chances they will appeal this matter, but it looks like Mogotsi is still willing to use the same legal representatives in this particular matter, of which I think that those two, they love media too much. And the worst mistake you can make for yourself as a client is for you to get a legal representative that likes to talk to the media too much. They disclose too much. They just always there doing a press brief, some kind of press brief around you. I just think that those legal representatives, in my view, people should stay away from them. Get legal representatives, guys, that focus on the case, don't want to be celebrities, just want to get you out of jail or help you win a particular case instead of just trying to be celebrities, seizing the moment, seizing the time. No.
We're not doing a bail application on new facts. We are appealing the bail, yes, in relation to the decision of the magistrate to deny bail based on the address. We believe that, specific conditions would have been more plausible under these circumstances, that he must report to the police station, he must not leave the province of Northwest. Those kind of conditions would have ensured that Mr. Nkosi actually comes and attends this particular matter until it's finalized.
So I don't know what you guys think about all of these 4 cases. What we know is that what we have learned is that don't lie, give the full version to the courts. They rather not give you bail and you move straight to trial than for you to lie to the courts regarding your personal circumstances, regarding your case, and not reveal the real truth, why you have the dockets in your house, why you have ballistic reports in your house of things that you don't even investigate. Just because you're a police officer doesn't mean that you should have all the copies of all the cases that the SAPS is dealing with. And actually, even in your house, that's my biggest problem. Just have everything in the office. What's wrong with that? Unless you had to work on that thing at home. But I think the best one is to just keep it in the office. Keep it in the office, and don't you find yourself in a lot of trouble with the law. Nonetheless, guys, let me hear what you think about these 4 cases. Just as other things that are happening before we end the video, there's reports that that General Shibiri has been dismissed and has been fired, even though there is plans that is going to appeal that. So General Shibiri, guys, is one of the people that revealed that he knows the cartel, because that's what he says. He says that he's a whistleblower and he doesn't understand why he's being arrested, he's being fired, and disciplinary proceedings was expedited and things didn't go well because of his testimony at the Matlanga Commission. But he considers himself as a whistleblower because he's the one who revealed information about the Big Five cartel.
I thought it was reckless from crime intelligence head, and I'm taken to be maybe against crime intelligence. I respect the men very much, and we worked along well, and with all of them, and they can attest to that. I got information, I called them, and it's my point of departure. But to come, what I had qualms with, to come here and say Shibiri gave us the name of the cartel. And you are having bodyguards 24 hours because of you don't want to be harmed by the same cartel. So that is what I indicated.
And also, this is the very man who was telling witness A and B that there's brown envelopes for them. So I just don't get it why he's just not taking accountability and going to that face the consequences of his actions, because even though he's denied everything, but if the DC finds you guilty, you're guilty. But we'll see what happens with the appearance. But we've also found out that more other police officers that are in connections to the Medicare 24 tender, they have been sent, given the suspension letters, and that most of them are going to be suspended, or they are being suspended. I don't know what you guys think about all of this thing that is going on in our country. Nonetheless, I will see you guys on my next upload. Bye.
These 12 cops were arrested earlier. Then we had the likes of Vusiket Matlala joining them in the dock. Then we had the National Police Commissioner General Fani Masimola joining them. We also have one civilian, a former associate of Mike van Wyk, who was at the center of these allegations, also in the dock in the Pretoria Regional Court. Now, we told also that there appears to be some indication that some of the people have turned state witnesses to 204, including unconfirmed reports. One of them is Mike van Wyk, the same person that you spoke to on ENCA some weeks ago.